Hey everyone, and welcome back to our channel. Today we're re-diving into a really important topic that affects the well-being and future of children. Legal guardianship, or as it's known in many civil law systems, tutela. We'll explore how a guardian or tutor is chosen and the different ways this can happen. This might sound complex, but we'll break it down step by step. First, let's talk about the most significant way a guardian is appointed by the parents themselves. This is considered the primary method because, naturally, the law presumes that parents have their children's best interests at heart. A parent exercising their parental authority can designate a guardian for their children. This is a personal right. They can't transfer it to someone else. It can also be done through a public deed while the parent is alive. However, for this parental designation to be valid, a few conditions must be met. The parent making the appointment must have been exercising parental authority at the time. If they made several appointments over time, the most recent one is the one that counts. The designation must be formally recorded either in a public document or a will. Now, what if there is no guardian named by the parents and no surviving grandparents to take on the role? That's when we get to the third type, dative guardianship. Here, a judge steps in to make the appointment. The judge will typically consult with a body called the Guardianship Council and will prefer to choose a relative of the child, usually within the fourth degree of kinship. The judge has to follow some specific rules. For instance, if there are multiple siblings, the judge can't appoint more than one guardian for all of them. They need one guardian for the whole group. If there's a conflict of interest among the siblings, a special temporary guardian called a curator might be appointed for each group with similar interests just to handle that specific issue. It's also interesting to note that someone leaving an inheritance or a gift to a child can appoint a special curator just to manage those specific assets. This can happen even if the child is still under their parents' care or already has a guardian. Now, let's briefly touch on a couple of other important roles, besides the main guardian. Or tutor, parents can also appoint a protutor. Think of this person as a supervisor or a backup. Their job is to oversee the guardian's actions and ensure they reacting in the child's best interest. Like the guardian, a progenitor can be named by the parents, but unlike the guardian, if the parents don't name one, there's no automatic succession to grandparents. Instead, a judge will appoint one. Then there's the guardianship council. This is a group of people who advise on and oversee the guardianship. If parents have designated people for this council in their will or a public deed, the judge will form the council with 4 of them. If the parents didn't make any designations, the judge will appoint 4 of the child's closest relatives. If there are relatives on both the mother's and father's side, the judge will try to pick from both lines. If there are no known relatives, the judge will select reputable members of the community, preferably people who were friends of the family. Of course, not just anyone can be appointed to these roles. The law establishes certain inabilities, which are reasons why someone might be disqualified. These are meant to protect the child by ensuring that only suitable individuals take on these responsibilities. These inabilities can be absolute or relative. Absolute inabilities mean a person cannot be a guardian for anyone, ever. This includes people who can't legally manage their own property, like minors or those declared legally incompetent. It also includes people with no fixed residence, those who have been previously removed from a guardianship for misconduct, or those convicted of serious crimes, people with no known job or who are known to have bad conduct, as well as those with alcohol or drug dependency issues are also absolutely disqualified. Relative inabilities, on the other hand, disqualify a person from being a guardian for a specific child. For example, if someone has a legal dispute with a child over their status or a significant part of their property, they can't be their guardian. Certain judges are also barred from being guardians for children within their jurisdiction. And very importantly, if a parent explicitly excluded someone from being a guardian in their will, that person is ineligible for that specific child. If an ineligible person somehow accepts one of these roles, their appointment is completely void. Once a suitable person is designated, they have a duty to accept the position. Guardianship is considered a public charge or a social duty. It's an obligatory office. Accepting the role is the first step. However, accepting doesn't always mean they start working immediately. Sometimes legal formalities need to be completed first. For example, members of the Guardianship Council might accept their roles long before they are ever called upon to perform a function. This duty to serve applies even to people who might have a valid reason to be excused. The excuse itself doesn't automatically get them off the hook. They must formally present their reason, and only a final court decision confirming the excuse can release them from the obligation. So, what are these valid excuses? The law lists them specifically. They include military personnel on active duty and ministers of any religion. People who already have 3 or more of their own children under their parental authority can also be excused, as the role would be an extra burden. Another excuse is being so poor that taking on the guardianship would jeopardize their own subsistence. This is different from being disqualified for having no known means of support. Here, the person has a livelihood, but the extra responsibility would be too much financially. Being the guardian or curator for another person is another valid excuse. Also, people who cannot read or write can ask to be excused. Finally, the law allows the impeded to be excused. The judge will evaluate these situations on a case-by-case basis. And that's a comprehensive overview of how guardianship is established and the responsibilities and rules that come with it. It's a system designed with many checks and balances, all with the ultimate goal of protecting the most vulnerable among us, children who have lost their parents.